Welcome. We're giving just a moment for people to join in, and we will start shortly. Okay. So welcome, everyone. Greetings from Fordham and the Institute on Religion, Law, and Lawyers Work in New York. Thank you for joining this conversation, part of our series on the new frontiers of human rights, the future of freedom of religion. My name is Andy Moraes. I'm the director of Fordham Law School Institute on Religion, Law, and Lawyers Work, and I'm honored to be moderating this dialogue. This is our fourth and final section on the series, New Frontiers of Human Rights, at least for this academic year. Let's see what the future holds. This project has been designed and promoted in collaboration with the Center for Research in Politics and Human Rights, PHR, at Sophia University Institute in Italy, and with the Observatorio de Derechos Humanos of the University of Valladolid in Spain. I want to take this moment to acknowledge this partnership and thank all those who collaborated on the success of this series. Really, thank you. And with that said, in case you want to check our previous conversations, our first webinar aimed at introducing the Human Rights International Framework. The second focused on transhumanism and how that might impact human rights protections. The third zoomed in on the situation of human rights in international borders, the case of migration. And these materials, all these materials are available to you on the PHR YouTube channel and on the Institute of Religion, Law, and Lawyers Work website. So feel free to check it out and share it with others as you please. And without further ado, let's get back to today's conversation. And let me introduce you our speakers. I'm privileged to be in conversation with Professor Jessica Giles, who is a law lecturer at Open University in UK, where she teaches EU law and business, human rights law, and corporate social responsibility. But most interestingly, I am fascinated by Jessica's research interest in the synthesis between law and religion studies, constitutional theory, and philosophical theology. This involves research into freedom of thought, conscience, religion, related fundamental rights, and legal scope of the legal scope of religious freedom in public life. She's currently working on the theoretical basis for freedom of thought, conscience, and religion in a comparative theological environment, focusing on non-Western liberal democratic contexts, which is super interesting. Welcome, Jessica. And then we'll also be in conversation with Brian Leppard. He is the Harold Conroy Distinguished Professor of Law at the University of Nebraska College of Law. He has written numerous books, chapters, articles on international law, comparative law, human rights, comparative religious ethics, and freedom of religion or belief. And his books include, I will cite a few, Rethinking Humanitarian Intervention, a fresh legal approach based on fundamental ethical principles in international law and world religions, Hope for a Global Ethic, Shared Principles in Religious Scriptures, Customary International Law, a New Theory with Practical Applications, and Re-examining Customary International Law. Professor Leppard is a member of the Baha'i Faith and is a former special assistant in human rights for the United Nations Office of the Baha'i International Community in New York. Thank you again for joining us. And as we start our dialogue, we know that the right to freedom of religion is a very complex right, and it varies within different legal contexts. We think about an international, legal, national context. So with that, I would like to start by asking you, both of you, to set the scene for us, to introduce and explain where we are at with freedom of religion from your point of view. I'll start with Jessica, and I believe you're gonna share an European perspective, but I don't know. Jessica, the floor is yours.
Thank you. So let me try this. So buona tarde, buonasera, and good afternoon. And yes, so what I'd like to do to start with is just briefly share something of my freedom of thought, conscience and religion journey, if you like. So how I came to be interested in it and how my research developed. And that hopefully will set a bit of a background in respect of the right to freedom of thought, conscience and religion itself. I was asked, and my journey started in around 2010 when a colleague came and said, will I start reporting some cases globally on the right to freedom of thought, conscience and religion for the Oxford Journal of Law and Religion. And we thought it wouldn't take much time, a few cases would be coming through and it would just be an interesting, something I could do on the side, as it were. And actually, as the work developed and as the picture came into more focus of what was happening in respect of religious freedom, freedom of thought, conscience and religion, I should say, globally, I became more and more involved in the work, and it sort of took over, and I came out of a job in the courts into academia and really became involved with the study more broadly. So what we saw really when we built a team and we took cases from jurisdictions, so from the Americas, from Asia, from India and from Europe. What we saw really was the refinement of the exercise within the courts of the right to freedom of thought, conscience and religion, particularly in Western liberal democracies, which I suppose had we thought about it at the beginning, we would have understood that, because we have the rule of law deeply embedded in those systems and the ability of individuals to exercise their rights in the courts. And we see human rights, and in particular the right to freedom of thought, conscience and religion, embedded within constitutional contexts. So the case law that was coming through was as much a demonstration of how the right was embedded within those cases, rather than the extent to which religious freedom might or might not be enjoyed within nation states. An example I can give you is Peru. Peru enjoys a relatively high level of religious freedom, according to the Pew Research Center, but we don't necessarily see as much litigation on religious freedom as we might see, for example, in European states. So having looked at a breadth of issues coming through in courts on the right to freedom of thought, conscience and religion, I then started to explore the kind of socio-legal context. So looking at writers such as Grace Davey, Putnam and Campbell in America, Jonathan Fox, looking at the Pew Research Center and some of the excellent research done by the US State Department about the extent to which religious freedom was and was not enjoyed throughout the world. And this, of course, since the 2000s, particularly since 2010, the Arab Spring, and then moving into 2017, the Rohingya crisis in Myanmar, we see more and more oppression of religious freedom and disintegration of peaceful plural living together across the globe. And this led me to look in my research at the extent to which we might still be able to regard the right to freedom of thought, conscience and religion as a universal right. We have it written into the UDHR, we have it into the International Covenant on Civil and Political Rights, we have it in the European Convention of Human Rights and other regional instruments, national constitutions, many national constitutions do include it, and yet we were seeing rising in the statistics of oppression of religious freedom. So I looked at a lot of the case law, a lot of the reports and the statistics, and it seemed to me that aspirationally, at least, I would say, it still could be regarded as a universal right, but we needed to do a lot more to bolster the actual enjoyment of that right. And one of the issues that particularly interested me, and something I think we're going to look at in this session, is we have this drive towards neutrality in some nation states in America, and then confessional forms of living together, certainly in some Muslim states, so exclusion of plural living together there. And we were getting this polarization, if you like, of views that sometimes perhaps a reaction. Paul Cliseur and Efshin Alian look at it in the Netherlands at Leiden. They talk about theoterrorism, a kind of a reaction to terrorism, which causes us to suppress the religious freedom and try and create neutral spaces. So what interested me is how we might think authentically, theologically about human rights, because it seemed to me if we just try and speak in a neutral space about human rights, we are going to deny what the Pew Research Centre tells us are 80% of the globe's kind of ethical frameworks or ways of living. Apparently 80% of the globe adhere to one faith or another. And yet if we try and exclude that religious dialogue and we don't talk theologically about law or about how we live together publicly, then we're really in deep water. We're going to have sort of massive public cognitive dissonance, because we have laws being created, but people living in different ways. So I started to explore both the theological approaches to the right to freedom of thought, conscience and religion. And with my own tradition being the Christian tradition, I looked at the doctrine of common grace within Reformed theology. And I looked particularly at a dialogic approach to rights and how we might base that on multivalent reasoning. So we're very, certainly in the Western tradition, we're very bivalent. There's kind of a right or a wrong to most things. You know, there's a winner or a loser in cases. Whereas I think some of the other traditions, certainly the Jewish tradition and the Islamic tradition, can sit slightly more comfortably with this idea that, well, we can have different points of view, but actually we can build consensus. And I think perhaps we can look at that moving forward under the legal framework of freedom of thought, conscience and religion to build towards consensus in society. So some of the big questions that I looked at in my research is, as I say, could we still consider freedom of thought, conscience and religion as a universal right? What underlying public theological justification can we find within the various faith traditions? Then how could we use freedom of thought, conscience and religion as a legal tool set in a wider context, so in a bigger toolbox to foster plural living together? And I look there at the idea of tradition. So within faiths, we have this core doctrine that's immovable, but often faith groups and other groups will have this set of rules that is their tradition that they can kind of adapt and contextualize over time, and it enables them to sit within societies. So I think the scope there for dialogue within those, so faith groups can reflect on their tradition, articulate their tradition, and look at where they can build consensus and move maybe. And then that really led me to look at constitutional theory. So I looked at the constitutional theory of Herman Dooyeweerd from the Netherlands, and the idea of sphere sovereignty and what he calls encaptic interlacement. So how we can resolve some of these rights clashes that occur between, although they come into the courts as between individuals, they're really between civil society groups. So the same-sex lobby and religious freedom, religious groups and conscientious objection and those who would have a more liberal view, perhaps. So how he looks at a kind of a philosophical approach to that and an ethical dialogue approach to that, really, that we can look at resolving that and living publicly together with difference. And this led me then on to a consideration of the interaction between the rule of law and religious freedom. So to what extent can we say that the rule of law and religious freedom are dependent on each other? And my conclusion there, and what I look at there, is the extent to which a society needs to develop virtue, the idea of virtue, and the ability to understand which virtues are important in order then to embed the rule of law, not just to, so Craigie, the Australian academic, says, you know, we have to be careful not to mimic the rule of law. We need to embed it. And to do that, I think we have to have a public discourse around our values and the virtues. So what we value most in society and which virtues we need to develop to embed the rule of law. So that's a real kind of whistle-stop tour of all the issues that I've been looking at in my research.
Thank you so much, Jessica. We could go on another hour just talking about these questions for sure, but let's pass on the word to Brian and hear what are his views on where we're at with freedom of religion.
Thank you. Well, that was fascinating, Jessica. I will really be eager to keep up our correspondence and collaboration here. So maybe following your lead, I'll just briefly explain my own trajectory in terms of my research on religious freedom, but then lead up to what I see as some of the major challenges to it today. So I was actually raised as a member of the Baha'i faith, which Andy mentioned. And so early on after college, I got my dream job working at the Baha'i office at the United Nations. And I got to focus on human rights issues. Among others, religious freedom. So I was able, just as a young, 21-year-old at the time, to attend a major conference in Geneva at the UN on freedom of religion or belief, and became very involved in that issue. Became involved in efforts among different religious NGOs to try to better protect this right in international law, including considering a treaty on religious freedom. Then that led me to law school, where I continued to research this issue, looked at some comparative law issues involving religious freedom, including doing a study on religious education in public schools, comparing US jurisprudence with Canadian jurisprudence. Then, my career ultimately brought me into academia. And there I was able to explore another dimension of religious freedom. And I should mention that one of the subjects I was very involved in at the UN was the protection of religious freedom of the Baha'is in Iran. The Baha'i faith is a world religion, but it was founded in Persia, now Iran. And ever since its founding in the 1800s, Baha'is have been severely persecuted, and that persecution has really dramatically escalated since the rise of the current government there after Khomeini was installed. And so as a result, I was always looking at this issue in part through the lens of the persecution of Baha'is in Iran. So, but one of the core Baha'i beliefs actually is also in the fundamental unity of religions. And one of the main goals of the Baha'i faith is to try to bring together people of different religions and different ethnicities and nationalities. And so this concept of the unity of the human family is really at the center of Baha'u'llah's teachings. He's the prophet founder of the Baha'i faith. That actually then helped motivate me with some of my research when I became a professor in terms of looking at shared perspectives on human rights, among other issues, among different religious traditions. And so I began investigating what different religious traditions had to say about human rights generally, about freedom of religion or belief, and many other related issues, which was my first book, which actually looked at humanitarian intervention, the use of military force to protect human rights victims. And as you can tell from that very long title of my book, which is practically a book by itself, I did try to bring religion in and religious perspectives and look at common ethical values of world religions to inform our understanding of international law. And so that then led to a whole nother broad line of inquiry, which was the positive contribution that religion can make to our understanding of human rights. And I later got involved with a project involving the drafting of the Universal Declaration of Human Rights by the world's religions. So it was an effort to look at the UN framework for human rights in the Universal Declaration through a religious lens. And so those two strands of research, I think, have really come together in my work and do inform my perspective about the current state of religious freedom in the world. So I guess I would like to, first of all, just echo what Jessica said, that I do believe that religious freedom is under serious threat in the world today. And I really see that threat coming from two directions. I think one of them is we do see a rise of what we might describe as religious fanaticism, extremism, and of course, that can take various forms. It can take the form of clashes between groups within a society. And the examples are just too numerous to mention right now. But of course, if a member of a particular religious group winds up in power and then is able to exercise that power to favor that group over other religious groups, then we see another, a much more systematic dimension to religious, I should say oppression, really, oppression of religious freedom. I mean, clearly that's the case in Iran, where you had a government coming to power with a rather extremist ideology, supposedly grounded in Islamic teaching, but actually, as I've argued, completely inconsistent with it. And it's attacking a minority group, right? And we see that pattern play out in many countries of the world. But then there's, I think, another threat, which comes from what we might call a more secular worldview that tries to diminish, perhaps, I mean, there's an understandable skepticism about religion among many people who have a secular worldview, precisely because it has apparently been the instigator of so many human rights violations. But that has led to a demotion of the status of freedom of religion or belief. Freedom of religion or belief is viewed as just another element of the personal freedom that any individual enjoys to make any kind of life choices, where to live, etc. And I believe that that's also a threat, because it can lead to including justifications, including legal justifications for oppression of freedom of religion, if it's regarded as merely another right without an entitlement to special protection. So I've also made the argument that freedom of religion or belief goes to the core of who we are as human beings. It goes to our moral and spiritual character, and our fundamental, even essential right to determine a moral course for our lives. And that this is therefore a freedom that deserves the utmost protection rather than the most minimal protection. So we can elaborate on that when we talk about, you know, legal issues and cases and so forth. But I would say that I do believe that religious freedom needs to be much more vigorously protected right now because of those dual threats.
Thank you so much. There is so much to unpack. And maybe we can start, well, before going anywhere, let me just say for people connected, if you're connected on YouTube, you can always drop questions on the chat box. And instead, if you are on Zoom with us, you can use the Q&A feature and also raise your hand if you are with us in the room. So with that said, please, I encourage you to send out your questions to us. But with that said, let's keep on going. And that, as I was saying, it's so much to unpack. And maybe the best way to start is really, and Brian, you just mentioned that in your talk right before, when you say, well, maybe we should look into a few cases just to give some examples, just to get people into concrete examples. You gave already the example of Iran and the persecution for the Baha'i community there. But I wonder if there are other contexts that we can explore. And besides, and I think both of you already touched on it, but I'm here wondering also, especially for the courts, how the interpretation of freedom of religion then take a flavor, a different color, depending on who is also enforcing, let's say, a protection for this right. And so, I don't know, start maybe with you, Jessica, if you could cite to us, bring us more close to one or even more cases, short, really short snapshots of how we can or how we had or not guaranteed freedom of religion and that was my alarm clock, just trying to keep us on time. So that you know what I'm doing. Everything is like timed, but in any event. So I was saying, case that we can also analyze this intersection between the neutrality, state neutrality, and the guarantee of freedom of religion or belief.
So what I like to do actually is do a comparison between the Court of Justice of the European Union and the European Court of Human Rights, because I think there's a really interesting way in which religious freedom is treated when we look at the neutrality of the state. So I'm setting aside issues where a state might have a kind of a religious ethos, some of the cases brought against Italy where the Christian values or historical Christian values are sought to be propounded, and looking at cases like France and Belgium, where the idea of neutrality in public life is something that's supported by the government, and where religious freedom issues come up against that, wearing of the burqa in public or the niqab in public or something like that. And I think what we have to consider there, we have cases both in the European Court of Human Rights and in the Court of Justice. So in the Court of Justice, we have the Achbita and Bugnawi cases, for example, where two individual employees in a private institution, in private business, wanted to wear the hijab to work, and customers complained. In one case, it was a complaint against one individual, but in another case, in the French case, there was a general policy of the company, no religious expression at work or philosophical belief expression at work. When we get to the European Court of Human Rights, we have similar cases. So the SAS case and the Baby Loop cases, where France has a law about banning the wearing of Islamic headdress in public, and also businesses, both public employers and businesses, are seeking to prevent individuals to manifest their religious belief in that way. And I think the comparison between the cases is really interesting. So in the cases in the European Court of Human Rights, we get support for the French government to decide to pursue this ban in public. And then in the Belgian case, the global kind of company approach is supported. So they can say, actually, we're not discriminating against one individual, but actually everybody in the company, if they have a religion or philosophical belief, they're all discriminated against, and that's acceptable. So now it seems to me, if a state has decided, a democratic state has decided to approach religious freedom in a certain way, that's one thing, and we could have a huge debate about that, but that's one thing. But the problem arises, and where I'd like to make the comparison, is where we have a certain effect of the court's judgments. The European Court of Human Rights can apply the margin of appreciation and can say, well, actually, France might decide to do that, but if as a court we find that acceptable, that doesn't necessarily set the baseline for the rest of Europe. So other countries in Europe will have a different settlement between the government and citizens vis-a-vis religion. So religious pluralism might find a different expression in the United Kingdom or in Italy or somewhere else. What we see in the cases that come before the Court of Justice of the European Union is that once there is this ruling within the Court of Justice, it applies throughout the European Union. And not only that, once a multinational company, for example, in Belgium, has permission to deny, to issue a blanket ban for everyone to express forms of their religious freedom, then that has application throughout the European Union, potentially in those countries which would otherwise have a different arrangement on expression of religious freedom. And my concern doesn't arise just there. I think my concern is that once, if we take that to its logical conclusion, if one is already banning outward expressions of religious freedom, it's not much of a step from that to individuals not being able to have a discourse that stems from the ethics or moral foundations of religion. So what do we do with forgiveness, mercy, all those attributes, if you like, or those virtues, which often stem from the practice of religion? And if we suppress that in our work environment, I think then we are in a very difficult situation, as well as in our public environment. So there's a really brief snapshot of some huge issues that come up, but also that we need to think about when we look at the different jurisdictions and how the courts operate, especially when they're regional courts and they have an impact. And we can talk about that a bit more perhaps when we talk about the European Court of Human Rights and do some comparisons with America later on.
Thank you, Jessica. No, that was very effective. And I will pass on to you, Brian, on the same question, right? This dilemma between guaranteeing freedom of religion and state neutrality. What's your take on it? If you can present that, obviously, the same question, right? A few cases or decisions on it.
Sure. And of course, it's interesting because this dilemma is posed really explicitly by the text of the First Amendment to the US Constitution, which on the one hand prohibits any establishment of religion by the state, thereby apparently calling for neutrality toward religion on the part of the state, while also guaranteeing the free exercise of religion by individuals. And so, of course, our Supreme Court has wrestled with how to both guarantee freedom of religion of individuals while also ensuring that there is no establishment of religion, at least one that is serious enough to run afoul of this clause in our Constitution. And obviously, this is a vast area, and I will be the first to say I am not an expert on US constitutional law. I actually rather focus more on the implications of international law for various policies. But having said that, it does strike me, having done in the past a study of US jurisprudence on religious freedom as compared to, say, jurisprudence of the European Court of Human Rights, and I will say I have not actually focused on the European Court of Justice, that there is a different approach. And I do believe that if one were to generalize, we could say that the US Supreme Court has been very protective of religious freedom of individuals because of the free exercise clause. And it's, for example, it will insist that any government regulation that impinges on freedom of religion by an individual must be given strict scrutiny. It must be carefully scrutinized, and there really must be compelling justifications for regulation. So it is given a very strong protection, and I think there are a number of recent cases that underscore the high protection given to individual exercise of freedom of religion. For example, recently after the onset of COVID, there were 3 cases where religious groups challenged apparently neutral local regulations limiting gatherings indoors. And just last year, the court, again, by a thin majority, but nevertheless, struck down some of those regulations that would have adversely impacted, say, Bible study groups' ability to come together in a private home because it involved more than 3 families. That was the regulation in California, and said that these unfairly burdened religion because at the same time, the state was saying people are free to go to get a haircut, right? They are free. And in these places of business that were allowed to operate, there could also be more than 3 households coming together. And so the court viewed that as an improper burdening of exercise of religion. And that was a majority. So that's one example of the court being very attentive to protecting that individual exercise of religion. You know, another is the Masterpiece Cake Shop case decided in 2018, which involved a baker in Colorado who did not want to bake a cake or design a cake for a homosexual couple, refused to do so. Later, the Colorado Civil Rights Commission or the local Civil Rights Commission, actually it might have been the state Civil Rights Commission, found that the cake shop had violated civil rights laws. But the Supreme Court said, in effect, that the refusal of the baker, who was a devout Christian, to make this cake based on his religious beliefs, was something that should be protected, and that the state had in effect discriminated against his free exercise, not only of religion, but also of freedom of expression, to design a cake or not. So again, there are decisions that really underscore the strong protections that the Supreme Court gives to free exercise of religion. I would contrast that with the approach of the European Court of Human Rights, at least in a number of cases, where, as you said, Jessica, by invoking this doctrine of the margin of appreciation, the court is willing to give a lot more deference than, say, the Supreme Court does to government regulation that would adversely impact individual expression of religious belief. Obviously, the Islamic headscarf cases being a prime example, cases that include, for example, Sahin versus Turkey, where the court upheld, at the time, a Turkish regulation forbidding even university students from wearing Islamic head coverings in attending class. And I believe, now, of course, as we know, the justification was, as you said, that different states within the Council of Europe may well adopt different policies and approaches. Some will adopt a secular approach, as Turkey did at that time. Others, of course, like Italy, may adopt an approach that, of course, acknowledges and celebrates the Catholic heritage of the country. And there, the court came to a quite different decision in Lauzi versus Italy, as we know, in 2011, where it found ultimately the Grand Chamber found no violation of the European Convention on Human Rights, merely because crucifixes were displayed in public school classrooms, because this, according to the court, was a legitimate expression of Italy's cultural identity as at least the seat of Roman Catholicism, and where Catholicism is part of the culture. So there's just a lot more deference given to the interests of the state, whatever those happen to be in the given case. And I find that to be an interesting distinction, worthy of further discussion and exploration. So I'll just highlight those few cases for the moment. Thanks.
Thank you, Brian, also for the comparison, very rich. And I was here listening to both of you, and I think Jessica highlighted already also these distinctions between even precedent, right, between the European Court of Human Rights and then the Court of Justice. And I'm wondering, and besides also now Brian making this comparison, and going back to what Jessica mentioned before of the importance of understanding ethics, religious values, the impact of that in culture, what really means, what do we really mean by cultural values, by religious values, and how they embedded, particularly in this case in Italy for the crucifix in the schools, and how the court decided. But with all of that, Jessica, we'll start with you again. If you could share, what do you see as weaknesses in the European system, in the international human rights framework system, and what are your suggestions for improving it? I'm sure that we could spend another hour here, but
thanks, Andy. When I reflected on the European Court of Human Rights, a big problem for me is that I think they're doing a great job, to put it in non-academic terms. I think one of the things we forget sometimes is they have almost a diplomatic role. We sort of see them either as a Supreme Court or a Court of Appeal or even the Court of Justice of the European Union, which they're not. Their judgments, once they're given, their decisions, once they're given, a state can refuse to comply with them, even if that's politically embarrassing. And that has happened very early on in the case of the UK, because... And so I think we must remember the role that they play, and that is why they have, for example, the margin of appreciation. But there are other aspects of the way that they operate that I think are conducive to encouraging plural thought and also supporting supporters of religious freedom. So I'll take one example, and that's the Perillo case, Perillo versus Italy, where a woman in tragic circumstances had lost her partner, and they had been going through IVF, and there was an embryo created. And the decision was about whether or not the embryo was her property, whether or not she could donate it for research. And the judgments in the case, so the resolution was that Italy's law prohibiting this could stand, but what was really interesting in the case was the judgments together with the dissenting judgments, and there was a certain freedom for the judges to really come forward with their ethically informed reasoning, and strongly based on either their atheistic position or their religious position. And there is something hugely healthy in that, I think, in that reasoning building consensus, so that individuals can read the judgment and really understand the moral implications and the moral thought around what goes into the final conclusion, and also understand the context for Italy of that decision. And that's an opportunity that arises because of this role of the European Court of Human Rights. So they have a role in creating a baseline. And again, with Italy, there's another great example, the Oliari case, where a group of individuals came forward and they were challenging the fact that there was no legal protection for same-sex couples. And they were arguing that it should be possible for same-sex couples to marry in Italy, partly because so many other countries within the Council of Europe had granted that to same-sex couples. And the resolution, the way that the court resolved that was they said, actually, it's come to the stage where Italy has to grant some sort of civil protection to same-sex couples. And it was that baseline throughout Europe. There was a stage that Europe had really reached where there was a baseline, and Italy was falling below it. But actually, because of the religious ethos within Italy, they didn't go so far as to say, and elsewhere in Europe, we might think of Spain perhaps, but they didn't go so far as to say all states within Europe should really be granting marriage to same-sex couples. So they set the baseline, but left it for states to grant better protection should they choose to do so. And this is what I mean by them being kind of a diplomatic court almost, as well as setting that baseline for rights throughout Europe. And it is, I think, a really difficult position to hold, but a really important one. This ability to keep an eye out for where rights are going, because when we look at the kind of moral and ethical reasoning within faith traditions, they're not static in many, perhaps in some forms of the more conservative aspects of religion. But for many traditions, they have this way of developing their moral reasoning over time. And to have a court that can work with that is really important. And I think the European Court of Human Rights does really well at that. I think one of the challenges, if I were to identify some difficulties, I think one is the exhaustion of domestic remedies that can be very difficult for individuals. I mean, this isn't particular to religious freedom, but to have the expense of going through all the domestic courts, and all reach that high bar of, well, it's impossible for me to win my case nationally, I've got to come to the European Court of Human Rights. I think that is a difficult challenge. But at the moment, I think they have a really important role, and that it's a role that they're fulfilling really well. So sorry to disappoint to not come up with increased criticisms. I think much can be done for religious freedom, but I think that the European Court of Human Rights is really responsive to what's happening at national level. And when we want to look at religious freedom, plural living together, we need to address that at a national context and encourage nation states to foster plural living together, both using the legal tool of religious freedom, the right to, well, it's not just religious freedom, it's freedom of thought, conscience and religion, so we must be inclusive there, and to think more carefully about public policy around that. So I hope that kind of answers the question.
It does. Also because, again, you right there at the end also gave this pathway forward in a sense of the intersection of what it is that we should look at, particularly at the national level and even more local level, but where these religious groups then are developing their own values and how the values intersect with nationally the country and the country within the region, which is in your case Europe, and obviously the impact of that for pluralistic society. And especially nowadays we are living in a time of polarization and the difficulties of creating spaces where we can really understand each other, because to come also to a dialogue, one should have a clear vision of one's identity. But if you also don't have this clear vision, obviously all the levels will get more and more complex and the difficulties will arise and maybe won't be able to tackle them, but given the complexity. So I think you address it quite well, if I could say so. Brian, what about you? What do you see as weaknesses? What do you see as challenges, and how would you address it?
So you'd like me to focus on the US legal system? I hate to be like the the defender of the U.S. system here, but I will, or critic as the case may be. I'll do my best here, since I generally like to think with more of a global perspective. But turning to the U.S. And our jurisprudence on freedom of religion or belief, I would just make a couple observations. So I think that one of the downsides of the great scope that the Supreme Court has given to individual expressions of religious freedom is that, to the extent we are seeing the polarization you were referring to, the rise of extremist views, we are giving more latitude then to individuals to adopt very discriminatory views and attitudes. If they're religiously grounded, especially when they're religiously grounded. And I think there's a danger there. So I can't fully explore that here in my remarks, but just to say that, you know, even, for example, in the Masterpiece Cake Shop case, by giving a great, now, of course, the ground of the decision was much more limited, finding, in effect, active discrimination against this individual because of his religious beliefs. But nevertheless, you know, by giving more latitude to individuals acting on religiously inspired beliefs that nevertheless others would view as very much discriminatory or prejudicial towards other groups, we run the risk then of undercutting those other human rights. Okay, so I'll just underscore that point. And then the other weakness perhaps of the US jurisprudence has to do with the Establishment Clause and the fact that in other cases, the court, now this is changing, but the court, you know, has demanded a kind of strict neutrality on the part of public authorities towards different religions. And one could argue that that does ignore the rich history of religious influence on our law, on our traditions in this country, and in effect deprives the state of the beneficial insights that can be gained from these religious influences. And so I think the European Court of Human Rights, through the margin of appreciation, has been much more respectful of the cultural traditions of the different countries that make up the Council of Europe and the important role of religion in those cultural traditions, acknowledging it, in effect, allow, you know, so for example, in the US, it would most likely be impermissible to have crucifixes hanging in a public classroom, okay, right? Because of this idea of strict non-establishment, strict neutrality in public places. But of course, in Lousy versus Italy, the European Court of Human Rights said, no, this is permissible. And so I think that there is more room, I think, for giving some greater deference to the positive influence of religion on different cultures. Now, again, the danger is it becomes an exclusivist type of religion. And I think that's the reason that our courts have been in the past very religious, if I can use that expression, about creating a rather sharp divide between public institutions, which have to be strictly neutral, and private ones as well as private individuals who have this right to free exercise. So I think that, but there's room for more discussion. And I've written about how many of our ideals about law and human rights and equal protection of the law actually have a strongly religious inspiration. And I think that we really do ourselves a disservice when we try to ignore that important positive connection between religious values and the broader values of human rights that we hold dear. So, just two questions for further thought and reflection there that might be viewed as critiques of our current approach. Thanks.
Thank you, Brian. Well, you're having a great conversation here. I am enjoying our conversation, but I'm biased. At this point, I want to ask both of you for a final word, but if I could direct a little bit the final word, it will be in a sense of, we have been talking about a pluralistic society. And so how to think about this religious plurality and secular values, also acknowledging that maybe different people has different concepts for secular values in itself. But with that said, how do you think human rights and human rights more broadly as a framework could help instead of prevent, instead of suppressing dialogue? So I think Brian was just now trying already to address that question in a sense in the very end, but I will just drop that there if I could address a little bit your final words, but I will ask you for that.
I'm sorry, did you want me to talk first or Jessica?
Yeah, no, maybe let's go back to Jessica again.
Sounds good.
You're muted, Jessica.
Sorry, I should be used to not doing that by now. Yeah, so I would say we have to consciously remember, in a lot of the literature and in a lot of the time we discuss it, we speak of freedom of religion and belief, or religious freedom. And I think we need to consciously think about freedom of thought, conscience and religion. So there's no kind of threat that there's going to be an exclusion even in our dialogue. And I've had to do that in my own writing, because actually what we see is religion is suffering, so we try and bolster religion and religious freedom by speaking about that. But actually what we want to do is make sure there is this plural dialogue, and there is something about just our terminology and the way we speak about it that I think is really important. I think we also, and this is a personal view of mine, and we don't hear it as much, but I think we need to sit comfortably with the idea that within a democracy, it is acceptable to have religious ideals supporting a majority, if that is what comes out of our process of democracy. It doesn't have to be that, if in a country we have a Christian Democratic Party that is supported by the majority, that's legitimate, but that must be protected by strong rights frameworks to ensure that other people aren't thereby disadvantaged. We've got so far with rights, and we have so much more of an equality approach, not equal. I don't think sameness is appropriate, but equality. And we don't want to lose that if a particular majority comes to the fore. And it really repeats some of what Brian was saying there. So, so I think that's really important. I think also we need to focus as much on human duties. And there are academic commentators like the O'Donovans, Oliver O'Donovan and Joan Hart O'Donovan, Hauerwas, Rowan Williams, they all are calling really for this coming back to the idea that we live in community and we have human duties. And if we look to Article 29 of the UDHR, it focuses, I just copied it out here, so we have duties to the community we live in that should allow us to develop as fully as possible. So we sit with this idea of human flourishing, and as humans we can only flourish not only in community but as communities that support each other. And then I would also suggest that we must think about the right to freedom of thought, conscience and religion, and what we need to support it. It is one tool in a toolbox, but we need an ethical discourse around that is based on multivalent reasoning. So we need to support that in societies with various approaches. I look at that in my research, and I'm not going to do that in my summary now, but yeah, so I think that's absolutely vital. We can't expect individual litigation to support freedom of thought, conscience and religion. We need to look at the bigger picture. So they would be my summary suggestions.
So Jessica, would it be right that when you're talking about this larger approach, looking at the big picture, as you mentioned, then education will be a strong path forward? Is that?
Absolutely vital. Yes, education, and then also this being more comfortable with dialogue, so creating opportunities in public. When we think about political dialogue, so much of our political dialogue is what I might describe as very surface, and we're not necessarily, we're more interested in the UK, for example, about parties in Downing Street than we are about the deeper moral dialogue around what's going on, partly because we're not encouraging that from the word go as much as we might do. So I think really we need to approach that much more broadly, both within society, within our education system, but beyond that as well.
Okay, thank you. Thank you. Brian, your final thoughts?
Okay, final thoughts. Well, I would definitely agree with Jessica about the importance of education. And I think that in looking at issues of freedom of religion or belief or thought, conscience, and religion, we do need to distinguish what is the role of the law from, what are desirable values that we seek to achieve. And law is not always the best mechanism to achieve certain values. I think education can be much more effective, depending on the context, obviously. So, other things being equal, I think that it's better to allow a greater scope of freedom to individuals to act on their religions or beliefs. And to the extent that those beliefs are discriminatory or prejudicial, then we should rely on education to help people come to a better understanding of other beliefs, other traditions. The model really should be one that encourages religious plurality and plurality of beliefs, but with an attitude of mutual respect and a desire actually to learn from one another. And one of the themes I've written about is how in every religious tradition we find this idea that actually it's beneficial to engage in dialogue with people of other faiths and other way of thinking, and to learn from them. This is often referred to as a concept of open-minded consultation. And again, you find it in all the religious scriptures. But this is a model, I think, for how our societies should think about these issues. And ideally, the law should facilitate that kind of dialogue and consultation and mutual learning. But I do believe that we are living in perilous times right now, where we do have so many extremist and polarized views, including ones ostensibly grounded in religion, that are trying to shout down and oppress others, that we have to be very vigilant. We have to be vigilant in safeguarding a fundamental floor of human rights to thought, conscience, and religion and belief for everybody. And then perhaps we work on the divisive elements through education, and especially education, the reality that the foundational teachings of all of the great religions, certainly the major religions, are ones focused on bringing people together and learning from one another and even celebrating diversity. So thanks.
John, do you have a question? We're moving on now to our Q&A. And so again, for people in YouTube, you can always use the chat box, also here on Zoom, and then we're gonna have John will ask live a question. John.
Yes, thank you, Andy. And then thank you, Jessica and Brian, for a very insightful presentation. This program comes at a really vital time, and especially in the recent happenings on the continent of the West Africa. On Africa. My question boils down to beyond constitutional guarantees and then legislative guarantees of religious freedom, where and how do we begin the most effective advocacy for religious freedom, especially now that in your presentation you talked about education. But a few days ago, there was a case involving a young female student who has been lynched to death based on a comment she made. And this happened in a higher institution for education, So it brings about it raises so many questions. And the interesting part is that she's from a country that appreciates and enjoys religion pluralism. There are several customary religions, Catholics, Christians, Muslims, etc. And she belonged to a higher institution, and then she had to face this ordeal and face her untimely death. So where, how, and what form of advocacy would work best as we try to forge forward? Thank you.
Who did you want to?
Yeah, both. I think feel free. Thank you, John. I didn't introduce John is one of our SJD students at Fordham Law School. So thank you, Jessica. Please go ahead.
Yeah, thank you for sharing that, John. It's incredibly tough when someone who is seeking to exercise their rights and comes up against such horrific behaviour, really, especially in a country or in a situation where they might not otherwise expect it. And it was interesting because at the weekend I was watching, there's a film on the suffragettes that follows the progress of some of the women who were suffragettes, and ultimately one of them who threw herself under a carriage, and the others who went on hunger strike in order to gain the right to vote and gain rights for women. And I think in particular women can suffer terribly in seeking to enjoy their rights, not even assert them, that they're entitled to them, but enjoy their rights. And I was weeping at the end of it to have an insight into the fact that my enjoyment of a right now that I never take for granted, but that I understand is available to me, was available to me because of the suffering and because of the self-sacrifice of others. So I think, first of all, that the women that follow, that they can understand the story, that we have an awareness of the costliness of the enjoyment of the rights, that others actually went ultimately sacrifice their lives for that. We must never forget that. So we must cherish the rights and exercise the rights. If we're not exercising those rights, then we are denying the incredible sacrifice and commitment that those come before us show. And I think also it's always difficult. It's always a decision as well as to best understand how to move forward and seek to enjoy those rights. So if it's for example in a country where it's normally acceptable to exercise those rights, it's understanding why in that particular instance what went wrong, whether the police services there or the security services there can address that issue, or whether it's a more systemic issue. And if it is a more systemic issue, how might that be addressed? And it's when we looked at it, certainly I was on a project and we looked at it in the exercise of religious freedom in countries within Asia and countries within Africa. And I think a multi-level approach is necessary. I don't think you can say address it in education, address it in government. I think it's a multi-level approach where you sort of win over the hearts and minds and you change the ethos, and it comes in diplomatic circles, it comes in government circles, it comes in education, it comes in private enterprise, it comes in public service. And there are various organizations, international organizations that do that. There's a fantastic organization called the Religious Freedom in Business Foundation, and they work globally and award prizes, in fact, at the Paralympics for businesses which facilitate religious freedom for their staff and support it in communities and that type of thing. There are some wonderful NGOs and INGOs, international NGOs, that work in communities to help individuals to exercise their religious freedom in certain ways. So I think it's tapping into those resources as well, and then working with some of the amazing work that's going on at an international level and seeking to get that body of support to come in to change a culture and really ensure that religious freedom is embedded within a culture, not just that we have a few dialogues or a few kind of showcase events, but really that we embed it within a culture and that individuals are comfortable. And we mustn't underestimate the challenge that it is to live with difference, you know, that we go out and we might have one point of view and it is acceptable for other people to have completely different points of view, but we build a consensus in society and we protect the freedom of others as well. It is hard, and I think we need to learn. The skill of doing that is something that we must learn and must seek to educate society on.
Ryan, you have any thoughts on that?
Sure. So, yeah, first of all, that is such a troubling story that John shared. I think it is illustrative of a broader problem, as Jessica alluded to, of violence against women. And interestingly, that's the subject of a book I'm now working on, is how to better protect women from violence, including I'm trying to incorporate some ethical perspectives that religions can contribute to this, even though, unfortunately, a lot of violence against women is perpetrated under the guise, I believe falsely, of religion. But more broadly, I think it illustrates that, you know, we absolutely need fundamental legal guarantees of freedom of expression of whatever kind, especially in places like, you know, classrooms at a university. But more broadly, you know, we have to guarantee those rights, and obviously then also protect people from violence, as in this case. Those are core values that all people share, of whatever belief, and it's fundamental that we guarantee them through law. But it does also raise this broader cultural challenge we're facing that we've both alluded to, I think, which is a rising polarization, rising fanaticism, extremism, an unwillingness to listen to other points of view, attacking others for expressing a different point of view. And I believe actually that religions, even though a lot of that antagonism can be carried out by people who purport to be religious, that if we look at the sacred scriptures of the world faiths, they all encourage us to speak kindly to others, respectfully. They urge restraint in speech. They urge us to engage with others in a way where we can mutually learn together. And these are values that we've lost. I think one of the prices that we've paid for moving to what we might think of as a more purely secular concept of human rights and taking religion out of it, at least in the West, is we've lost a lot of these respect for these moral virtues. of listening and of engaging in respectful dialogue that religions properly understood have taught. And I believe that it's important to really emphasize those positive contributions of religious values. And this doesn't have to be, as I've said, coming from any one religious tradition. I mean, they all have resources that encourage this kind of respectful dialogue. So that's an urgent need in our societies today, because really, I think you can point to virtually any country now and see evidence of increasing hostility, polarization. It takes different forms in different countries, but it seems to be a global phenomenon right now. Thanks.
Thank you so much, Brian. And yes, I second what you're saying, that really, I think all of us can really see this rise in polarization globally, unfortunately. And I think also maybe a small takeaway personally that we can take from this conversation is also ourselves try to apply more in our lives the principles that you just described, right? If it starts with each of us also to advance these new ethos, as Jessica was describing before. We have another question, another hand raised, that is Nathan Johnson, also JD student at Fordham. And let me just try to, there we go. Nathan, please.
Hi, thank you so much to everyone. This is such an insightful and great panel. And it's a little intimidating knowing how knowledgeable and thoughtful you both are. But I had a question that goes back to what Professor Lepard, you were talking about in your opening statements, and a little bit to what Professor Gals, you spoke about in your closing statements. First was one of the threats to the right to freedom of religion, which was the extremism. And in discussing that, Professor Lepard, you mentioned the possibility of a majority religion taking political power, and then the threats that may pose to the right to freedom of religion. And Professor Gals, you touched on that as well. And I'm wondering whether, and this has actually arisen in my international human rights course at Fordham, whether there is that threat or potential undermining of the right to freedom of religion requires an overt act or active discrimination against other religions, or if a mere constitutional or legislative provision to the effect of recognizing a state religion or recognizing a special place a certain religion holds in a society can similarly pose a threat to the practice and protection of the right to freedom of religion within any given state, or if it requires this more overt discrimination. Thanks.
So did you want to direct that to both of us then, Nate? That question?
Yeah, sure. And I'm thinking, Professor Moraes actually mentioned to me recently how Israel recently passed a law that officially established it as a Jewish state. And I'm thinking of Myanmar has a provision in its constitution that I believe recognizes Buddhism as a special plate, holding special place. So those are the examples that I'm thinking of currently. And to either of you, yes, sorry.
Well, I'll defer to Jessica. Well, that seems to be our pattern, and I'm happy to do it because I always learn a lot when she.
Oh dear. Well, so it's a great question, really, really important one. So, yeah, I think it's always easy to think of bad examples and then think, well, because there's a bad example, it must be wrong to have, for example, a majority religion in power, if you like to put it. I mean, there's a more nuanced way of putting it. And I often come across this because we have establishment, we have the Church of England in this country. And it's viewed as a slight anomaly, or, kind of what does that mean to have an established church? so my view is that actually, if you have a faith-based organization that understands the importance of pluralism, which is basically understanding the importance of free choice for human beings, then you're safe. But if you have an organization, a faith-based organization with power, whether that's in government or just has power within a country, and it doesn't understand the importance of free choice, then that's the problem. So that's the issue. It isn't so much whether an organization which views neutrality as important, and by neutrality I mean exclusion of religious expression, or whether you have inclusive secularism, which is some states' way of incorporating this kind of plural voices, or whether you have a confessional state. What's of absolute essence is the understanding of whether moving out in and out of religion is permissible, and whether the idea of freedom and free choice is important within society. And one of the arguments I make, and I'm exploring this at the moment, I haven't fully explored it, but it's based on William Temple's idea of middle axioms. He was a former Archbishop of Canterbury that had ideas about how post-World War II, how we rejuvenate society to build consensus together. And I think my thoughts were that actually we almost need a commission of pluralism, and it sounds rather kind of alarmist. I didn't mean it like that, but actually, if you can keep a track of whether pluralism is supported in society and whether you've got the capacity of individuals to live together, you can then work within a democratic context to elect. You're going to elect a group that has a certain viewpoint. You either elect, in the UK it's the Conservatives or Labour, or potentially the Liberals, or a coalition. You work within a democracy. There are certain groups which will come to power and exercise power, and the issue is not, and the issue there is are other groups, minority groups in society and individuals protected. And I think that's what's important. And the motivation behind that, the way that the group argues itself to its moral consensus for that group and for society, it might be based on a group of humankind getting together and saying, well, we go with Aristotle, or we go with Plato, or we go with whoever we go with, that's how we reason our way. Or if that's faith-based, that there is going to be some basis where they reach consensus within the party and within the political organization of society towards the creation of laws and adjudication of laws. But why rights frameworks are so important, and why religious freedom is so, freedom of thought, conscience and religion is so important, is because that is what protects a society from kind of going off the rails, if you like. So that's how I would, that's where I'm at, if you like. But there are, of course, other great thinkers who've thought through it in a much more sophisticated way, including Brian.
Ryan?
Yeah, so, this really is a fascinating question you've raised, Nate, particularly because, as Jessica acknowledged, so many countries we think of as upholders of democracy and human rights actually have some kind of established religion. And this is really remarkable. I've not done a comprehensive study, but just in my own research, I found that, I would hazard a guess that most countries of the world may well have some kind of religion given favored status in some way. Mm-hmm. And even, for example, the Constitution of Iraq, which the US helped draft, after 2003, talks about Iraq being a Muslim country and gives a privileged status to Islam, even though it then goes on to say that it will guarantee full freedom of thought, conscience, and religion to everyone, right, and to all groups. So I think that's one point to note, is that, many Western democracies today are examples of how an established religion legally can coexist with broad respect for pluralism and human rights. Now, beyond that, though, I think there's a larger point to really reflect on, which is the potential gap between law on the books, and the books can include constitutions, and the law in practice. And unfortunately, what often matters, I mean, the law on the books is critical. The law on the books can often be a brake on extreme measures that a particular government may want to take, because it would so clearly defy, say, a constitutional guarantee of equal rights. However, the reality is that a determined government can interpret a constitution any way it wants, essentially. Now, it may ultimately have to change the constitution, but unfortunately, even constitutional guarantees may not be sufficient in the face of extremely powerful political forces that seek to undermine those values. And this is a challenge that all countries face, I think, is that there can be this huge gap between law on the books and law in practice in both directions. I mean, you can have a constitution that looks amazingly liberal, like our Constitution did and has. It is a great model of respect for, equal protection of the laws, the idea of everyone having inalienable rights. But then, look how we've treated Blacks in practice. Like there can be this humongous gaping chasm between the law as it's written in a constitution and how it's interpreted. And then conversely, as I said, you can have a constitution that gives a lot of privileged status to a particular religion, and yet that religion is understood to be tolerant, pluralistic, open, and that's the actual practice. I mean, I found it fascinating doing some of my historical research that some of the great European political theorists, like John Stuart Mill and among others, praised the Islamic world for its religious tolerance and said, we European Christian nations have a lot to learn about tolerance from these Islamic nations. Because there was this ideal of religious pluralism in the Quran itself. The Muslims were to respect and engage with Christians as Jews as equal communities, and that they should help one another and consult with one another to be more just and moral and God-fearing. And they were, Christians were allowed to apply their religious law to their internal affairs, same with Jews. I mean, this was the ideal. Now, of course, then what's the reality today? Well, it could be quite different from that. But the point is that I think that as lawyers, it's essential to have these guarantees, right? In constitutions, in statutes, civil rights laws, et cetera. But we always then face the challenge of implementation. And so, I mean, I can point you to some academic studies about constitutions and different degrees of establishment of religion. It looks like someone in the chat also pointed out a study by Jonathan Fox, very interesting. So thank you, Jessica. So again, it's a big subject, but those would be a few thoughts I have.
Thank you, Brian. And maybe we're gonna close our Q&A section with Dr. Al-Shankiti. She's also a Fordham alum. Let me see if I can pin her here. Yushra, you're there. Can you?
Hello. Can people hear me?
Yes.
I'm sorry, I'm not without. I'm without a picture. It's about 8:30 here in Saudi, so I'll be off to bed in like 30 minutes from now. But I
yes, also connecting from Saudi Arabia. So yes,
I don't want to miss this for the world. So this was a really informative and very interesting discussion, and thank you very much for that. My question, and I wouldn't say a question, it's more of a comment. Based on your experience and research that you've done, what would you say is a good baseline or ground to use as a guideline when discussing freedom of religion in the academia? And my question stems from this idea that in the academia, there's this perception that the discussion of religion and law are not how would I put it, are not very intelligent, for lack of a better word. So what would you say is a good practice, is a good baseline, or a point that someone who is in the academia uses?
Usually, if I can just reword your question, because we had a few conversations on that point, but even with Brian, when I have a phone call back, it was always like, how can we overcome the skepticism in academia as we work on legal issues and yet are trying to bring this dialogue also with religious values? So basically, I would reword this way.
Thank you, Andy. Exactly.
Yeah, sure. Shall I jump in? Sorry, we've been following that pattern. Is that okay? Yeah. Just a brilliant question, and so important, because you've got to engage people. You know, you could have a whole wonderful presentation, but you could start it and lose people at the start because they already think that they're not going to be interested in what you're saying. So I do understand that, and I understand that especially because my research synthesizes theology and law, and the methodologies are so different there. You know, law, very objective, based on rational reasoning, and theology, and certainly the Christian theology, the theological tradition I come from, it's legitimate to be slightly subjective in your reading of the scriptural text. And so I can go to theological conferences and everybody listens. I can go to legal conferences and everybody listens. But as soon as I kind of take this interdisciplinary approach, it's a challenge. The way my training is as a barrister and the way I approach it depends on my audience, but a very strong way of approaching it is with evidence, especially with academics. So really thorough research. So Pew Center, and if individuals are going to dispute the methodology of the Pew Center, the US State Department, if one's concerned about Western bias, find some evidence elsewhere. As I say, Jonathan Fox is excellent in his research of the entanglement, if you like, of religion and government across the globe. He's had Templeton Foundation funding, or he's had funding to do some excellent research, and looking at where you might find the evidence that is going to convince those in your environment. So particularly in Saudi, there is QAICID, fantastic organization doing excellent work. Saudi government, Spain, and which is the third? There's several big players. Andy, you know the other person, the other.
I think it's Austria, because they are located in Austria.
Yeah, Spain, Austria, and Saudi Arabia. So they've been gathering evidence, and so it is understanding your audience and understanding what it is they need. Often in the debates I go into, it's fear that is creating a barrier. So fear of changing a way of life, fear in what it might mean for the society. And in fact, one thing I did in a society that was in civil society breakdown, I created a dialogue around an issue that I thought everybody could not agree on, but find common ground on. So, and that was in this society, I looked at the issue of whether or not a witness should be allowed to wear a hijab or not. I.e., when you're giving evidence in a trial, is it necessary to see the face in order for evidence to be given? And that is, you know, that was one issue I thought it's important for a society. They need to discuss that in order to reach a decision on the justice of a situation. And they could also discuss different viewpoints of it. And you could discuss the role of women and you know, bring that in. But there are other examples you might be able to think of where that it's slightly more neutral. You know, some of the issues we talk about are quite they're almost they set off a spark in the discussion where it becomes difficult. People have very entrenched views. So I would suggest evidence and then finding issues which people can talk about and where there's scope for movement, and use scriptural reasoning. It's really powerful to use scriptural reasoning based on the scripture of the group that you might be addressing. Or if they don't buy into scriptural reasoning, use arguments from within the tradition they come from, the atheist tradition or whatever. Anyway, I've spoken for too long.
Thank you, Jessica. Brian, do you have something to add? Or
I think I realize we're out of time.
Yeah, exactly.
Technically, but I would just echo Jessica's points. And I would just say that, you know, as an academic who's also religious, one way to engage with others who may not be religious is, you know, to be very factual, including, importantly, understanding the very important influence, very positive influence that religion has had on the development of law, including international law, you know, throughout the world. But as I said, we've almost tried to sanitize that history and take religion out of it in the academic world. But a fair examination of it would reveal that many of the great founders of international law, certainly, but no doubt this is also true within countries, were devoutly religious, and they brought the very positive, more humanitarian, more inclusive teachings of their religions to bear in their work on helping to build these national legal systems and then the global legal system. And I think that's a fact, that's a historical fact that you can draw on in citing to, you know, these esteemed luminaries in the legal world. So anyway, I'll leave it at that, but thanks.
Thank you so much, Brian. Thank you so much, Jessica. Thank you so much for our audience, but it was such a pleasure to have this conversation. I really enjoyed it. It was really enriching, and I learned a lot. So thank you really very much. And for all our audience, please stay tuned. We hope to continue this series in the next academic year. We'll see, but for sure, you're going to be receiving some emails from us on that respect. Thank you again.
Thank you.
Thank you
Bye,
all.
everyone.
Bonsoir, to finish the language.
That's right.
Abend.
It was
think
great.
That's the limit.
Ciao, ciao.
Ciao. Yeah.
Bye,
you.
everyone.
Thank
Thank
you.
you.
Bye.